Hello everyone, good evening. On behalf of Daksh, I welcome you all to this event, the launch of our latest book, Constitutional Ideals, Development and Realization Through Court-Led Justice. It's an immense honor and privilege to have with us this evening Justice B.V. Nagarathna, who is currently serving as a judge in the Supreme Court of India. Justice Nagarathna has kindly consented to preside over today's event and release the book, and we are very grateful indeed for her presence and her time. We're also extremely happy to have with us in our midst this evening the Chief Justice of the Karnataka High Court, Justice Prasanna B. Varale. We are also joined by Justice Sunil Dutt Yadav and Justice Shukre Kamal, both judges of the Karnataka High Court. A very warm welcome to you, ma'am, and sirs, and thank you so much once again. I'd just like to take the opportunity here to give you a brief introduction to Justice Nagarathna's distinguished career. After obtaining her LLB degree in 1987 from Campus Law Center at Delhi University, Justice Nagarathna practiced law in the courts in Karnataka. Her practice included a wide variety of cases in areas such as administrative law, constitutional law, commercial law, and family law. She represented the Karnataka State Legal Services Authority and High Court Legal Services Committee and was appointed as amicus curiae in several crucial cases. In 2008, Justice Nagarathna was appointed as a judge of the High Court of Karnataka. During her tenure, she served as the president of the Karnataka Judicial Academy and the president of the Bangalore Mediation Center. She contributed a chapter on the courts of Karnataka to the book Courts of India, released by the Supreme Court. She also served as the chairperson of the committee in charge of bringing out the Kannada translation of the book Courts of India. In 2021, Justice Nagarathna was elevated to the Supreme Court of India, and she is in line to become the first woman Chief Justice of India. We are particularly grateful and honored to have Justice Nagarathna with us today because the grace, integrity, dignity, and empathy that she brings to the cause of justice is an inspiration to us all who are working in this space. Welcome again, ma'am. Before we begin, just a very brief word about the book. This is a curated volume of essays featuring contributions from a diverse group of researchers and practitioners, all of whom explore how courts have developed constitutional ideals in the face of political and social change. In this book, we delve into fundamental principles such as dignity and equality, the balance between individual rights and group identities, the importance of procedural rigor in achieving substantive justice, and much more. Several of our authors and contributors are also present here today, and we're very pleased to have you too. Welcome to you too. Now, if I might invite Mr. Sundararaman to come forward and present a copy of the book to Justice Nagarathna so that she may do the honors. Thank you very much, ma'am. May I now invite you to give us your address?
Good evening and namaskar to everybody. Honorable Chief Justice Prasanna Kumar Varale, Honorable Judges of the Karnataka High Court, Justice Sunil Dutt Yadav and Justice Shukre Kamal, Sri Raganand, Senior Advocate, Sri Harish Narassapa, Senior Advocate and co-founder Daksh, and one of the editors of the book, Ms. Aparna Chandra, Associate Professor, National Law School, Bangalore, other editors of the book, learned contributors to the book who are in great number today, other senior members of the bar, and all members of Daksh and Oak Bridge publishers, distinguished invitees, ladies and gentlemen, and friends. I was to come a little later to Bangalore, but the function today has really attracted me to advance my coming to Bangalore from Delhi. and I thank Daksh for that. I think it's a privilege to release this book today, which has been published by Daksh India and Oak Bridge Publications. My congratulations and kudos and compliments for all the rigorous empirical research that has been done and gone into this book, which goes into the functioning of the higher judiciary in India. Aptly, the foreword is by Hon'ble Justice Madan B. Lokur. The volume, titled Constitutional Ideals, Development and Realization Through Court-Led Justice, breaks new ground. The essays touch upon the role of the Supreme Court as the sentinel of the Quive Way in advancing and evolving the constitutional ideals, inter alia, of dignity, equality, free speech, and democracy. I must say that the Supreme Court has played a crucial and a facilitator role in this discourse of social ills and systemic malaise. As citizens of a constitutional democracy, we must all recognize that our Constitution is not just a legal document, a historical event which took place when it was enforced on 26th of January 1950. It is a living tree, according to me. And the life into the Constitution has been infused, not just by the courts, by governance, by the executive, by the parliament, but by we, the people of India. The Indian Constitution is a product of anti-colonial and progressive mass movement which has bold aspirations. It bears as its core the anti-colonial founding ethos, which are impressed in the preambular principles, the fundamental rights and directive principles of state policy. I would say that the Constitution of India is indeed transformative of the Indian society and one of the most enduring constitutions till date. We have seen democracies breaking out of the colonial rule, setting up their own constitutions and governance. But how many such constitutions have really endured? Therefore, I must compliment not only those who are in governance, the courts, in the adjudication process, but the people of India who have made it an enduring one. The volume which has been just released today has a rich interdisciplinary approach in the essays and is an ode to the fact that the Constitution cannot be read in abstraction from the political, social, and economic context. I just went through the book. Of course, the PDF copy was also sent to me. And I find that the essays are of individual rights, group identities, systemic conundrums, and institutional responses, which are written about insofar as our republic is concerned. I congratulate the editors of the book, Ms. Shruti Vidyasagar, Ms. Sandhya PR, and Ms. Anandita Patnaik, Sri Harish Narassapa, and all the contributors who have lent their thoughts in bringing about this book and in curating the same. I congratulate Daksh and Oak Bridge Publishers for publishing this book and for inviting me to release it. Now, the book is called Constitutional Ideals. According to Judge Learned Hand, ideals are ultimate. They admit of no reduction below themselves. So, too are certain irreducible constitutional ideals which underpin the survival and success of constitutional order and concordial society. Ideals of a constitution are an expression of the overarching objects of a constitution and are so fundamental that they precede the very framing of a constitution of a country. The real value of a constitution would therefore depend on the extent to which it is successful in achieving the ideals. There is something in a constitution that is even more primordial than the structure and the features. To this enlightened audience, I need not go into the nitty-gritty of the various chapters or the various structures of the Constitution of India. But the ideals are what were thought of by the founding fathers in their wisdom and sagacity, which is inbuilt into the Constitution itself. I may tell this audience that with each passing decade, we will realize the wisdom of our Constituent Assembly members and what great forethought they had in 1940s to bring about such a constitution containing the ideals. But let us not just have a constitution containing ideals. The whole object is to implement them, to see that they are put into practice and they endure. The challenge is when the endurance is challenged. And that is where we, the people of India, must rise to have this knowledge of the constitutional ideals, because they can never be reduced. Those can only increase the standards of what is written in the Constitution, either through court process or through enactments or through other ideas being exchanged in society. But we can never bring anything below what is embedded and entrenched in the various chapters. Now, what are these ideals? Where do we find these ideals? How can the judiciary act as an enabler in the development and realization of these ideals? Because the focus of this book is on the judiciary being an enabler. The quest to answer these questions must begin with the study of the preamble. Perhaps, I think, one of the most poetic part of any constitution. The preamble is reckoned as a transformative instrument for forwarding the ideals cherished therein and the philosophy endorsed by the Constitution. It embodies India and Indian polity as a sovereign, socialist, secular, democratic republic, and the kinds of ideals to be secured to its citizenry, namely justice, liberty, equality, and fraternity. Therefore, according to me, there are two-pronged or two-dimensional classification of ideals in the Constitution. One, those that are reflective of the nature of nation's polity, the inter-institutional balance, the framework of distribution of powers between the different organs of the state as envisaged. And the second is the relationship between the citizen and the state. We as constitutional law students must go on reading the preamble. According to me, with each passing year, with the passage of every decade, the preamble throws light to a greater and greater extent. What the preamble meant to the court, Supreme Court in 1950, is different from what it meant to the court as well as to the people in 1970 or 80 and in this century. That is why I say that the preamble, which is really the heart of the entire Constitution, must be read and reread over the years to get the real meaning. That is why I would commend every one of us who is interested in being an enlightened citizen of India to have an understanding of the preamble of the Constitution. No doubt the Constitution lays down the basic structure of the country's political system, such as federalism, republicanism, parliamentary democracy, tripartite system of governance, and the ideals which surround them, namely institutional checks and balances, independence and integrity of institutions. But the other side, where the citizen-centric ideals are concerned, of course, all of us know the fundamental rights, the fundamental duties and directive principles of state policy are the ideals for a welfare state such as India is. It is therefore essential to understand these ideals, and that is what the attempt and the endeavor of the book has been. I would say that the first gift of the Constitution to we, the people of India, is to have the institutional foundation for the functioning of a democracy, and we continue to remain a democracy. A parliamentary democracy functions according to certain postulates, the most important being the responsibility of the executive to the legislature, and through the legislature to the electorate of the country. Another important postulate which has been in practice is the peaceful transfer of power or governmental authority from one party to another, either as a result of adverse vote in parliament or after a general election. It presupposes a multi-party system founded on the concept of collective responsibility, which in turn is based on deliberation, criticism, and exposition. But in my view, we as a nation can assert that we are delivering the ideal of democracy only when A, elections demonstrate how robust democracy is, B, parliamentary proceedings show the vibrancy of political debate, C, in the public sphere, from the social media to everyday tea shop conversations, shows enlightened awareness and engaged citizenry, D, there exists a strong opposition, E, institutions remain autonomous, F, free speech remains sacrosanct, subject to reasonable restrictions, and finally G, when the government functions within the bounds of law. If these have to remain, it is we, the people of India, in whatever calling, position or status we may be, must endure that the authorities or organs of governance remain within their bounds and democracy ultimately thrives. The judiciary in India has played a critical role in strengthening the idea of democracy. To this enlightened audience, I need not go into the case law because it is already written in the book and known to you all. But in Keshavanand Bharati, the Supreme Court said that parliamentary democracy is a basic structure, part of the basic structure. In Indira Nehru Gandhi versus Raj Narayan, it was observed that the rule of law and free and fair elections are basic features of democracy. In Quixoto Holohon, which is with regard to the 10th schedule of the Constitution, which is now very much a matter of debate, the Supreme Court recognized the complexity of political practice in contemporary democracies and took the view that the ideal of democracy could be secured through a variety of institutional mechanisms. Another ideal of the Constitution is federalism, which is a gift, I must say, to a large country such as India. We all know that we were about 600 and odd states, provinces, princely kingdoms, or whatever you may say. Scholars call the Indian Constitution as quasi-federal or a union of states, but according to me, the idea which lies as the basis of federalism is that each of the states should have equal political rights and thereby be able to maintain their independent characteristics within the larger union. Whether a state is a small state or a large state, industrialized or not, having more of scheduled castes and scheduled tribes or less of such population, each state is in that way a state to be considered on an equal footing with every other state. The central government or the union government must play the role of a parens patriae and ensure that there is no discrimination between the states themselves. The role of the Supreme Court in adjudicating disputes which have a bearing on the powers of the federal government as well as the states was recognized in State of Rajasthan versus Union of India, where the satisfaction of the president to issue a proclamation under Article 356 when being mala fide or based on irrelevant considerations or on extraneous considerations could be examined by the court. This decision highlights that the failure of the central government to function as a parens patriae of the states within the Union of India would enable the court to ensure that the constitutional obligation is enforced between the Government of India and the states, and in order to secure the constitutional ideal of federalism. The next ideal, I would say, is of interinstitutional balance. Although we all have known about the separation of powers, which started from the Montesquieu's theory of separation of powers, which actually postulates that each institution has some power to regulate, but it actually postulates that each institution has some power to regulate the functions of the others. This is in the form of an ancillary principle of checks and balances. To this audience, I need not highlight about judicial review and the doctrine of abrogation, etc. But each organ of the state must acknowledge and respect the autonomy and independence of the other co-equal branches. Neither the judiciary nor the parliament or the executive is supreme. What is supreme is the Constitution of India, which we, the people of India, have given to ourselves. Elected governments and political executives must recognize and respect the constitutionally accorded role of the judiciary in a democracy based on rule of law. Similarly, the judiciary must continue to remain conscious of the Lakshman Rekha, which is the constitutional Lakshman Rekha, so to say, of interinstitutional balance, which requires that legislative wisdom or the exercise of executive discretion not be interfered with without there being any basis for the same. Just as no executive or government can question a court as to why it decided in a particular way, I feel similarly, the court cannot question the parliament as to why it made the particular law. It's ultimately left to the wisdom of the authorities concerned. The only thing is whether the law is in accordance with the Constitution and the other tenets of, or what we call rule of law. Similarly, a judgment can be criticized only if it is not in accordance with law and not as to why a particular view has been taken. That is what I say are the checks and balances underpinning the Constitution. From this ideal of inter se balance between the organs flows another important ideal, and that is of independence of institution. A nation can only be as independent as its institutions are. The judiciary, the central bank, the election commission, public service commissions must all be independent and autonomous and act within the bounds of law. Institutional independence has an inverse relationship with external influences over the authorities. The lesser the influence, the higher will be the scope for functional autonomy. In this context, I would like to highlight that the independence of the judiciary is one of the most cherished ideals of the Constitution. We, the judges in the courts, value this the most. It is the freedom that is given to us under the law, under the Constitution, to decide in accordance with law. Judicial independence demands that judges need to be impartial and insulated from political pressures, and to be so within a broadly defined institutional scope of authority from the judicial branch. In my personal view, ultimately it is the personality of the judge which matters. Howsoever we may say that the judiciary is as an institution is independent, I would go a step further to say that it is the personality of the judge which finds its imprint in the judgment that he or she delivers. These are some of the ideals with regard to the various organs of the Constitution and the nation's polity, as so far as nation's polity is concerned. So with your permission, I think I'll continue a bit. The next aspect is on the ideals of relating to citizen-centric ideals, that is relationship between the state and the citizens. I would say that the first of this is the ideal of justice, which is enshrined in the preamble. What is justice? It is ultimately harmonization of interests between an individual and a group, and between a group and another group. The ideal of socio-economic justice was central to the founding fathers. This is ventilated in Articles 14, 15, and 16. Further, Article 38 and 39 tries to secure or endeavors the ideal of economic justice, and there are various aspects of justice as an ideal under the Constitution, such as socio-economic justice, which requires another day to debate upon, and therefore I will leave that topic at that. But another ideal which is of great importance to us today is liberty. The lofty preambular ideals have been precisely defined in Chapter 3 of the Constitution. The Supreme Court initially did not really move on with the spirit of Chapter 3, I think. They were more cautious, circumspect, and the judicial balance was not really tilted completely in favor of the spirit behind Chapter 3. But in the subsequent decades, the Supreme Court and the courts in India have interpreted Chapter 3 in such a way that it has been expanded, particularly Article 14 and Article 21, to include rights of the highest amplitude, such as the right to bodily integrity, right to die with dignity, right to reproductive choice, right of self-identification of gender, right to privacy. I think we should look at Chapter 3 as an open cauldron where various rights could be inserted or thrown into it. It is not already saturated. It is not already full. There is a lot of space within the cauldron for the courts to ensure that many more rights are recognized. And for that, we require not only an enlightened citizenry, but an enlightened bar to assist the courts to really recognize these rights. I may give two examples. In People's Union for Civil Liberties versus Union of India, the court recognized that right to food is a part of Article 21 of the Constitution. And that was in 1997, which later on prodded the Parliament to come out with the National Food Security Act 2013. Similarly, the right of the public to government information was a campaign which started in the late 70s, which ultimately culminated in the Right to Information Act 2005. The courts have therefore been at the forefront and led by the Supreme Court in securing the constitutional ideals of liberty. And it is for the people of India, we the people of India, to ensure that liberty remains with us. Justice, liberty, equality, and fraternity are the ideals enumerated in the preamble. But I find that justice, liberty, equality has not been of the same level as fraternity. Or to put it in other words, fraternity has not reached the level as justice, liberty, equality. Fraternity even today remains the least understood, least discussed, and perhaps the least practiced of the four ideals spelled out in the Constitution. Fraternity, which signifies the dignity of the individual and unity of the nation, must be emphasized in today's world. Dignity of the individual is accomplished by recognizing the moral equality of individuals, upheld through mutual respect, despite all our differences of religious belief, caste, language, culture, ethnicity, class, and gender. It is the Constitution which, according to me, binds us, and hence it is that very book which has made us to remain as one nation and will continue to do so for times to come. The idea of the unity of the nation being derived from fraternity is even more significant. Fraternity, according to me, will help in deepening democratic values in our society. But I must add one thing here, that the ideal of fraternity has, to some extent, found its elaboration in Article 51A of the Constitution in the form of fundamental duties. I need not narrate what are the various fundamental duties. But I must say that in today's world, the essence of fundamental duties is to achieve an ideal citizenship. When I speak of a citizen of India, it is not just a relationship between the citizen and the state and the duties of a citizen towards the state. It also encompasses the duties of one citizen towards another. Now, whether there are vertical rights and horizontal rights, I would not like to discuss today because that itself is another longish debate. But when we look at these aspects holistically, we must realize that to become ideal citizens, we need to cherish and practice the values of the Indian Constitution and also preserve and hand over those values as also the values of the Indian society to the future generation. Now, when we talk of values of citizenship, in my view, the value of integrity is of the highest. But alas, with the passing of every year, integrity is losing its value in our total value system. Bribery, corruption, and flaunting of ill-gotten wealth has become the order of the day and has been entrenched in Indian society. Disproportionate assets possessed by certain persons, especially those in public life, are hardly thought of as black marks in our society. In today's scenario, the word affordability is losing its meaning. There were times when people used to think several times, if not twice, before spending on luxuries or on material comforts. While the country has grown economically, which is a very good sign, and there have been greater generation of incomes amongst the people, what is of great worry is disproportionate assets, that is income from other than known sources, which is a worrying factor. We may progress as a nation, economically, socially, claim ourselves to be world citizens, have a great constitution, but if we lack integrity, what is it at the end? I wonder as to why there is no protest from members of the family of public servants who are indulging in bribery and corruption. If we have to be ideal citizens, then the time has now come to take a pledge against graft and also to practice integrity as a way of life. I would appeal to everyone to shun benefits obtained from ill-gotten money. If there is a determination made by everybody to refuse to benefit from graft, the need for such filthy lucre would automatically reduce, if not disappear. But for that, there is a need to determine to live within the known sources of income, whatever may be the attractions, consumerism and materialism. We have to shun materialism and consumerism and devote greater attention towards being ideal citizens of the country. Then only we could maintain and ensure that our constitution remains and gives us strength as a nation. Next, I would proceed to another ideal, which is secularism. Unlike in the West, in India, secularism was never born out of a conflict between the state and the church. It was perhaps rooted in India's own past history and culture and was very much a response to her pluralism. Secularism, in the sense that it is meant under the Indian Constitution, is that the state does not owe loyalty to any one religion. The state equally respects all religions. The vision of the founding fathers was that a nation transcending all diversities of religion, caste, and creed, to bring about a new social order based on justice, social, economic, and political. The Constitution has sought to establish a secular order under which the religious majority of the population did not enjoy any preferential treatment at the hands of the state, and the religious rights of the minorities were protected in different ways, even under the Constitution. Indra Sawhney versus Union of India and S.R. Bommai versus Union of India are two decisions where the concept of secularism has been discussed. First, the separation of the temporal from the religious, and second, the spirit of neutrality and tolerance. Before I end, I would like to refer to Bijo Emmanuel versus State of Kerala, which has, through the words of Justice Chinnappa Reddy, said, "Our tradition teaches tolerance. Our philosophy preaches tolerance. Our constitution practices tolerance. Let us not dilute it." Unquote. It is in that context that I highlight the constitutional duty of tolerance, without which democracy would be placed under a siege. To achieve the noble ideal of secularism entrenched in the Constitution, tolerance is a key virtue. I may also quote, but I would not do so, but only refer to Navtej Johar versus Union of India, wherein Justice Dr. Dhananjay Chandrachud, as his lordship then was, and the present Chief Justice, has referred to constitutional morality and the duty of all the citizens. The tenets which I have now discussed are the basic ideals of the Constitution. The authors of the book may have identified many more, but I haven't had the time to go through it in such a detail. I suppose in the discussion it will come out. An introspection as to whether these ideals have been secured in the Indian context would also provide a template for conversation about building a better tomorrow. We as a nation have come a long way, but we have a longer way to go before truly meeting all the ideals of the founders in the sense that they were envisaged. Fortunately, there is a framework towards achieving these ideals, a framework provided by the Constitution itself. A more democratic, a more equal, a more just, and a more tolerant nation continues to remain an ideal, even in contemporary times. Before I conclude, I once again congratulate everyone who is involved in conceptualizing, writing, editing, and publishing this worthy book. The chapters of this book are testimony to the wide tapestry of lives and laws that our Constitution touches, moves, and inspires like a North Star. With this, I end, thanking each one of you for your kind attention. Namaskar.
Thank you, ma'am, for your insightful ideas, especially for taking us through such a comprehensive journey of the constitutional ideals, many of which we have discussed in a book, but also to give us refreshing new ideas to think about, like, for instance, the linkage between fundamental rights and fraternity. So this gives us a lot of thought and ideas to work on in the future. Thank you, ma'am. I'm also glad to include Justice Swaminathan, who has joined us here today. He's from the Madras High Court. Thank you very much, sir. I'm also proud to say he's one of the contributors of our book. Now we will have a discussion on the themes of the book by Mr. Harish Narassapa and Dr. Aparna Chandra. Mr. Narassapa is a senior advocate at the High Court of Karnataka. He's the co-founder of Daksh and a founding partner of Samvad Partners. He's the author of Rule of Law in India, A Quest for Reason. Harish has extensive experience in advising on cross-border mergers and acquisitions, banking, corporate financing, private equity, projects, and dispute resolution matters. Dr. Chandra is an associate professor of law at the National Law School of India, University, Bangalore. She researches and writes on constitutional law, human rights, gender and the law, and judicial process reform. Her current research focuses on rights adjudication by courts, gender and the law, and empirical legal studies. I now invite Mr. Narassapa to begin the discussion.
Okay, so what we will do is try and highlight some of the topics that we have addressed in the book. Of course, as editors, our job, although I have a joint chapter in my name, but as editors, our job was more to identify topics that we thought required attention because of the changing jurisprudence over the period of time. And Justice Nagarathna alluded to this as to how we are a living constitution and all that. But I think what we want to do is take that concept of living constitution thread by thread and take certain concepts and understand them in the way the courts have led the development of justice. So that was the whole idea. And it was quite a long time in the making, and I must apologize to the authors who waited patiently for it to be published. And many, Justice Swaminathan, Ms. Naganan, Sundararaman, so many authors here. I think the chapters actually came more than 12 months ago, and then we had to request some of them to update it as well. So apologies for that, it took some time. So what I will do, Aparna, with your consent is, just highlight, so there are 4 broad themes, right? And then I'll just mention it and maybe then request you to take the lead on any one of the topics that you want. Individual rights and group rights is one thing that we identified. And in a way, while we can sort of pat ourselves on the back for identifying the topics, I mean, because some of these issues are now again being dealt with by the Supreme Court. There have been, recently 2 Constitutional Bench decisions. The hijab case is yet to be decided by the Supreme Court, but the equal marriage rights for all individuals is being discussed. The essential religious practice test is being questioned and thought about again. And this is something we discussed, both with the authors and amongst the editors, as to whether the entire concept of essential religious practices is a bit outdated. Was it something that was thought of by the court when it was, first used to interpret certain rights? But does it still have the same standing, or does it need to have a relook? And I think Sandhya deals with that in her chapter. So that was a sort of first, sort of equality, dignity, which Vikram Narayan deals with in his chapter. And dignity has now become a benchmark to link various other rights and give new meaning to Article 21 and even Article 14 to some extent. Then equality, I mean, what does equality mean, particularly now in the context of the increasing importance, in my view, of fraternity, at least the attention being paid to it by the courts, and what Justice Nagarathna also mentioned in her talk. The other topic that I thought we could deal with over the next half an hour is this interinstitutional tension. While I think scholars are always happy when there is tension, because I bread and butter. But I think I actually recollect a conversation that I had with Justice M.N. Venkatachalaya, and he said that in some context, he said, in a public function, I think the then Prime Minister of the day apparently said, "I hope to have good relationship with the Chief Justice." And he said, as Chief Justice, I told him that, no, I don't want to have a good relationship with you. I want to have a proper relationship with you, and that they should, the way institutions have good relationship is if there is some element of tension between the institutions. But of course, and now again, the Constitution Bench has recently heard, the Maharashtra case and the entire 10th schedule and where that will go. And both Prashanto Sen and Nikhil Majithia in their chapters deal with this. What happens, I think, while we are focused on the executive and the judiciary, we're not focused that much on parliament and the judiciary. And increasingly, functioning of the parliament, whether holding no confidence votes, whether holding for confidence, disqualification, various elements of the essential functioning of the parliament are now being questioned in the courts. And how far should the courts go? For example, Nikhil asks a question, is it the Supreme Court's job to even say, okay, have a vote on whether who has a majority on a particular day, prescribing sequence of events, and things like that, right? And of course, the question is, if the speaker is not doing it, then who else should do it? So that's the second element of the theme, which I thought, of the 4 topics, I thought we could look at these 2 topics. But of course, if you feel that there's something different, then we can go with that. But maybe you can respond to some of these things and then take it from there.
Sure. First, I should congratulate you and the entire team of editors and authors for this really well put together volume. As someone who teaches constitutional law, I know this is going to be very invaluable in my work and for my students in thinking about our constitutional adjudication more broadly, but our constitutional discourse. You use the language of development, which suggests movement. And I think that comes across beautifully in each of the chapters, how movement has taken place. And to my mind, there were 2 movements that I could see, and I think some of that was touched upon by Justice Nagarathna as well. 2 movements that I can see, and we can think about what the consequences of those movements are. One movement that I did not see, which has been Daksh's forte outside of this book, which I hope we can also bring to the conversation today. So the two movements that are very evident from each of these chapters is that, to begin with, the court sees the Constitution as a book of rules, and it interprets it in this rule-bound, technical, doctrinal way. And that movement, the movement there is from that kind of a rule-bound, as a rule book, to thinking of this as a charter of values. And that's where your hearing of constitutional ideals comes in as well. And for example, Vikramaditya Narayan's chapter on dignity, I think, really captures it. Your chapter on equality captures that idea of how the court starts using this value of equality as the basis on which to adjudicate a range of issues, which it might not have been able to if it had stuck to the idea of fundamental rights as rules necessarily. So there's that shift. I think in parallel, and in many ways connected to that shift, is a shift in the role conception of the court itself. And to my mind, the initial starting conception that the court has is of its own role is that of a checks and balances institution, which goes to the idea I want a proper relationship with you, because the role of the court is very often in tension with the role of with the work of the other branches. It's a checks and balances institution. Its role is to check executive power, to check overstepping of legislative power, so on and so forth. And Upendra Bakshi has said, and I think it seems to be, I think it's eminently sensible, that that role conception has shifted to the idea that the role of the court is to co-govern the nation. And this idea of co-governance, PILs being possibly the best known example, with the idea that the court will march hand in hand with the executive. On the one hand, of course, that has completely changed the space and the place that the courts occupy in the polity and in public imagination. But I think some questions have to be asked on what have we lost in that shift of role conception. This is not to say that the role conception is not required, or that we need a very rule-bound checks and balances kind of approach to constitutional adjudication. But I think this is the kind of power that then gives courts, who are also wielding public power, I think is a question that we should at least put on the table, right? That kind of a role conception might also often mean that the governance imperatives can drive constitutional adjudication in a way that you would think that rights should. And that kind of a concern with, the broadening of the kind of objectives, for example, for which rights can be limited. The details, including more and more expanding rights, which is very valuable, but then using this expansive rights vocabulary to limit other rights can also become a matter of concern. The third shift is the institutional shift. From being, for the Supreme Court at least, from being a cohort of 8 judges who are sitting in large benches, to the current court that we have of 34 judges, mostly sitting in 2 judge benches. This is where, of course, this is the other work that Daksh does. The institutional changes that have happened over the last 75 years, I think have had a role to play both in how the role conception has changed, how the approach to the Constitution has changed, but also some of the concerns that we see here, the kind of movement that's very often comes across as noise, because it's not very clear what direction the court is moving in. I think that's something to flag as well.
Let me take you up on, by the way, the one last topic which I do want to address is technology and judiciary and access to justice. And there are 2 chapters in this book, particularly how the judiciary responded to COVID, that address this, which I'll come to in a bit. But looking at, I have 2 questions on what you said in terms of marching hand in hand. Now, as as somebody who teaches constitutional law and who studied constitutions and constitutional court behavior in other courts, is that something that we should really care about? I mean, is it imperative on the courts to have this marching hand in hand concept? I would think, they should not, because that's not the duty of the courts. That's my first question. Second, you talked about governance imperatives. Now, should courts really be concerned about governance imperatives? And, countering what Professor Bakshi has said, if you look at what someone like KG Kanabran has said over the years, he always said that, the courts have treated the executive like an errant child, very gently over the years, and not really as somebody who is in breach of rights. So, whereas, and the only exception that I can think of is this, the entire 2G kind of case where the courts wielded a hammer rather than a pencil or a scalpel. So with that kind of discussion going on, should judiciary be really concerned about governance imperatives? I think I'd like to hear from you about that. Yeah.
I two things to say about that. As the notions of justice, the demands of justice that the public has changes, I think courts have to change along with it. Because if they don't, then there's a fear that they will face a legitimacy crisis. So if you look at what's happening in the 1970s, when a lot of the shift is happening, apart from the emergency and, the challenges to it, with the court really giving its stamp of approval to the emergency and the problems that happened, the other dialogue that is happening between the executive of the day and the judiciary is that we don't have a committed judiciary in terms of the values that the executive is seeking to espouse from the constitution, taking from the directive principles of state policy, so on and so forth. And in Keshwanand Bharati, there's a line which encapsulates this, right? To say that there is a lot of criticism of the courts that we are a forum for legal quibbling of men with long purses. And that's all that we are. And the courts are obviously very consciously changing this kind of an orientation post the emergency, perhaps for very, just to sort of regain the legitimacy that they've lost. But I think it's very difficult for courts to say when there is a shift in the understanding of the kind of justice that we require from the states, for the courts to say, but we will stay away, and this is not something that we will do. The question is, how do you do it? And I think therein lies the problem, that it may be that the needs of the requirements of the time is that courts need to step into a larger arena of matters that they would not have otherwise. But what kind of remedies do they provide? What do they see their role as? Is their role to look at whether the executive has done what it is supposed to do? And if it has not, to push the executive to do whatever it is supposed to do? Or is it the court's responsibility to actually formulate the policy? Now, I should say, I think the courts have been fairly nuanced on this. We don't have a good theory of constitutional remedies in India, but if you look at broadly what the courts have done, is they've pushed the executive to account for why it has done what it has done in terms of not following through with its policies, so on and so forth, in socio-economic rights matters. Where I see the problem happening is this kind of, we're just going to nudge, we're just going to push, also taking place when it comes to civil liberties matters. So in that checks and balances, early rule-bound approach, if you look at the first equality case that you discuss in your chapter, Anwar Ali Sarkar, 1951, court is giving a very deferential understanding of what equality means. But what does the court do? It strikes down a law that has been used to convict. Who is Anwar Ali Sarkar? Anwar Ali Sarkar is waging war against the state. He says he's waging war against the state. He's blowing up an airport, so on and so forth. And the court says, you haven't followed, says to the state, you haven't followed the law. We are striking this down. Today, with all the wealth of jurisprudence, I don't know that the court, with all its ideals and jurisprudence and doctrines and so on and so forth, is necessarily going to take that kind of an approach. So I think civil liberties is a space where the legitimacy that the courts have gained with respect to socioeconomic rights jurisprudence has somehow eaten into what the work, or has overshadowed the often very problematic things that the court has done with respect to civil liberties.
So it's an interesting point that you make, and correct me if I haven't understood that properly. You're saying that in the early decades, the court looked more at rights and processes and didn't really worry too much about the result. Whereas today, even though I'm sort of taking your thought forward, so if I'm putting words in your mouth, please let me know. But today, even though with the rich jurisprudence that we have, where it can support not only an analysis of the rights, and because the rights have been, the scope of the language in the Constitution has been expanded to include a variety of rights, whether it's 14 or 21 or even 19 to some extent. What you're saying is, are today's judges also concerned about the result as to whether X or Y is going to be affected or not? Is that something that you notice?
It appears that is what appears to be the to underlie much of the reasoning of courts. And very often they say this expressly, sometimes they do not. But if you look at, for example, the way in which courts talk about balancing rights, right? When someone is asserting a rights claim, to say that, so let me give you an example. It's a case called G. Sundarajan versus Union of India, where the Kudankulam power plant, there's a challenge to the constitutionality of the setting up of the Kudankulam nuclear power plant. And the argument, of course, is that it poses a risk to the life of people who live near the power plant, and therefore it violates the Article 21 rights. And the court says that, yes, there may be a risk to your right to life, but that's a remote risk. But there is a larger collective right to development that the country as a whole has, which is also a component of the right to life. And that will be protected if we have energy security. And therefore, in balancing these rights, this is the value that we have to give greater impetus to. You see this kind of reasoning in the Aadhaar judgment as well. So I'm just to therefore say that I think in this kind of, as the language has expanded, as values have expanded, there is a fear that can allow, that on the one hand, that can allow the courts to interrogate rights questions more deeply, but at the same time, that it can also allow for greater restrictions on rights if the question of what is the role of the court is not clear. And my sense is that we haven't discussed very openly what the role of the court should be in this sort of expanded universe of rights adjudication.
Okay, and I think it will take us some time if we want to go into depth on that. But just in the interest of time and moving forward, well, before I go to the technology and access to justice, I thought we could perhaps look at two more points. So one is, 2 points. One is around free speech. So there are two articles, one by Leah Verghese, talking about the heckler's veto, which seems to be now entrenched in our society. Even before it reaches the court, I mean, once it reaches the court and what the court is a separate issue, but the failure of authorities to support freedom of speech, once a heckler, in whatever form, starts objecting to something, and it's almost as if the police and other law enforcement agencies have accepted the existence of the heckler's veto based on who is in power. Okay, and I mean, again, to give clarity, I think freedom of speech has always been endangered in this country. I think irrespective of which political color is in power, but somehow this is a question. Then Sundar and his co-author, Varsha deal with the power of contempt I mean, while it's two different spectrum, two different points along the spectrum of freedom of speech. I mean, how does a court interpret the power of contempt, and is the court being too finicky about certain issues? And we have again examples. I mean, with the Supreme Court itself, where they sometimes say yes, there is contempt. Sometimes they're happy to let it go. Again, it seems that who is speaking rather than the content. So again, we go back to the identity of the individual. So that's something, that's one aspect. The second aspect is, since you talked about development and you mentioned this Sundararajan's case, interestingly, we don't hear so much about environment jurisprudence anymore. I mean, although we have the Godavarman case, going on and on and on, but and Justice Swaminathan deals with, the development of the environmental jurisprudence and how that, came about in his article. So perhaps if you could, quickly reflect on these two issues.
I think, again, with free speech is actually a very good example of what I was discussing earlier about governmental imperatives, right? Governance imperatives. So the first amendment to the Constitution, which expands the scope of restrictions that can be put on free speech, comes about, of course, as a result of two court judgments, which strike down the Madras Maintenance of Public Safety Act and the Punjab Public Safety Act, because they are not inconsistent with the exact wording of the Constitution. The exact wording of the Constitution at that time gave lesser powers to judges for free speech adjudication, because the exact wording was that there is freedom of speech and expression, all citizens have freedom of speech and expression, but the state can restrict the speech on certain grounds. The word reasonable with respect to those restrictions was missing, which meant that courts could not get into whether the restrictions were reasonable or not. Courts struck it down on a very narrow understanding of what public order means. Today, if you look at the language, and I don't mean only the Supreme Court, if you look at the trial court language, right, on what is public order, what is what are the imperatives at the level of the High Court, at the level of Supreme Court, of law and order, public safety, they're read so expansively that much of the logic of those earlier cases, which with very limited judicial review are striking down restrictions on free speech because you need speech, and it's only in very, very, very exceptional circumstances that the state can limit speech. So I think that kind of governance imperative, we need law and order rather than we need more speech. I think that shift is I think that's coming through. On environmental jurisprudence, I think, of course, we've had a very rich body of jurisprudence, and I think, again, it bears looking into the kind of remedies that the courts have awarded, because they're very sophisticated remedies that the courts have awarded. One reason possibly why you're not seeing so much of that is, of course, the creation of the NGT, and that's obviously also a growth of the environmental jurisprudence in a different way. So the Supreme Court might not be the site where a lot of these environmental questions are coming up, though with climate justice, and given how, again, intertwined climate justice is with questions around development, I don't think that the judiciary can necessarily escape that question. I think that other chapter that's there in the book, which is talking about privatization and globalization, yes, will speak directly as we go along on the court having to grapple with who has obligations to ensure that all the panoply of rights under Article 21, including the right to clean environment, who has those kinds of obligations, what kind of obligations that they have, so on and so forth. So I think it's a good thing. I think that development of that jurisprudence has come to a point where you have statutory developments, where you have other institutions which perhaps may be better suited to taking those conversations forward. And I think that's a success story. I will say, though, that there should be more, I think, the interrogation of how the court frames the question of environment. So, for example, we know that under the environmental jurisprudence, there is the contest between rights of the environment, rights of people who subsist on the environment, for example. So, forest-dwelling communities have been put at risk because of discourse around environmental rights. Right to development sometimes takes precedence over rights to employment. So I'm forgetting who said this, that seems to be a hierarchy of rights: right to development, right to environment, right of vulnerable people to live off the fruits of environment. And if right to development conflicts with the right to environment, it's the right to development that wins. If the right to environment conflicts with the rights of marginalized communities, then it is the right to environment that wins out. So I think there's a question to be asked there as well.
Okay, so just in the interest of time, how much time do we have, Ananta? Are we close to 10? Okay, so maybe the last topic we thought we could deal with is technology and access to justice, and how COVID sort of changed the game for the judiciary. And now I think today's newspapers carried an article that's a dampener on using ChatGPT in arguments in court. And because I'm not sure how many of you read, but I think some ChatGPT apparently made up fictional cases when a lawyer happily used the arguments by ChatGPT with the cases in the US. This happened in the US, not in India. And he submitted it, and then they realized that, hang on, none of these cases exist. So, and then there's other things going on. So as lawyers, I suppose the lesson is our careers are safe for a while to come. So I think, but just in terms of how, one of the things that we have complained about is access to justice. And somehow the one positive, at least as of now, the one seemingly positive outcome of COVID as far as the Indian judiciary was concerned was the accelerated use of technology, particularly video conferencing, to hear cases, remedy cases. And I know the current Chief Justice has essentially said, listen, continue on this road. Don't dismantle infrastructure that you have set up. And we know that the e-courts phase 3 is actually pushing us to adopt this at almost every court level, and kiosks for accessing courts. So you need not sort of go to courts, and Orissa is leading the way. And what we have seen is they've established different. You actually don't need to come to Bhubaneswar to address the High Court anymore. So and that's an acceleration that we saw. But there are also other problems that come with technology being used so much. For example, if cases are being argued and everybody, so it's one thing to say you can come to courts and watch open proceedings, and it's another thing to say it's available on your phone, so just log in and watch. So what are the impacts on privacy, data, and other things that there? But so that's a secondary point. But just in terms of access to justice, and I know you have written about access to justice, do you think this is a game changer? I mean, in terms of access to justice, and how should the judiciary? Because it's so in e-courts, in technology, the judiciary is not just an arbiter; it's actually implementing in a way the technology that it wants to use. So it has a governance role as well. So what do you feel about this and access to justice? Yeah.
I'm almost tempted to turn the question around to you, since you have much more expertise in this matter. And I would love to get your views on this as well. But I'll just say a couple of things. Just to say that as long as, I think technology can be a great leveler and a great enabler of greater access to justice, as long as it is seen as that kind of a tool, and it is repeatedly interrogated to see whether that purpose is being served or not. I think the fear with technology is often that people who are advocating for technology get caught up in some sort of tech utopia, that technology will, save us all. And of course, that leaves behind people who are not well versed with technology, or do not have access to those technological resources, or can have a range of unintended consequences as well. So it's just a different paradigm that we are living in with this kind of access to technology. And just to give one example, our entire criminal justice system is founded on the assumption that people change, people reform, and it is fundamental to the human condition that people are capable of change. That is what human dignity means, that we do not typecast people on the basis of who they were or the identity that they bear, so on and so forth. With technology, everything that you've done in the past is part of your digital identity, right? And that can shape obviously your material identity as well, or your identity in the real world as well. So one question that courts are increasingly confronting is the right to be forgotten, right? When you have all these cases, high courts across the country are facing challenges to Indian Qanun, which is fantastic in giving us access to court judgments from across the country. But that means that if I type in a name of someone who's been involved in a case, that's going to likely to come up on the first page of Google searches as someone who's been involved in this case, and the kind of repercussions that might have for that person. So I think we need to mediate, therefore, technology as well. And understand that it's not just a sort of single vector linear progression, more technology is good, but to think about the value framework and the principle framework within which any adoption of technology takes place. I think ChatGPT is a great example, because ChatGPT, the way it functions, or any AI any of the tools that we have currently functions, is that there's a black box where we don't know where they are getting the information from. What is the source of that information? Who has produced that information? What is the reliability of that information? And it can be incredibly dangerous if law, which is based on authority, right? You have to tell us where you got that proposition from. Who said it? Did a 2-judge bench say it? Did a 5-judge bench say it? We rely on authority. The entire, at least the common law system, is based on precedent and authority. I mean, the world of ChatGPT is a very different world. So that's something that we need to definitely confront.
So I think I was mentioning, I'll answer that question, but there's the second article. So there were 2 articles on how courts dealt with COVID. One is technology and values, but also the Varsha and Siddharth D'Souza point out the challenges, at least in this country, where there is a great digital divide, not only in the public but even amongst lawyers. And there have been many lawyers, for example, who have had challenges while video conferencing was allowed. But many lawyers had challenges about accessing, because not everybody had an office, not everybody had a laptop or an iPad or whatever, and sometimes judges told off lawyers who are appearing from their kitchens or appearing from their cars, and told you're lowering the dignity of the court by doing so and so. So there was an exclusion in a way in that process as well. But I refuse to sort of take that COVID experience as something that can set the tone. We can learn from it, but it was a situation where everybody had their backs to the wall. I mean, either it was allowing for video conferences or it was shutting the courts. And I think the courts chose to be operational in some form or the other. So I think while there are many learnings from it, but we can't take that as a template. But what certainly excites me and many of us who are working. One is technology in the courts. That's a separate thing in terms of court processes and efficiency, and whether technology can help court processes. That's what that's one aspect of it. But there's an access to justice aspect, which I think goes beyond process and efficiency, and the advent of Zoom and others, and the acceptance of video conferencing by the courts, I think has opened a great door to access justice. And the many challenges that we face in terms of access to justice, I think can be solved with, of course there are caveats, and of course there are, sort of other issues around privacy and data and others. For example, while many lawyers, amongst lawyer friends, we have a question about whether cross-examination of witness on a video conference is possible, or does it have the same weight as cross-examining somebody physically. But it does open up the possibility of, say, a police officer who is transferred or a medical officer who is transferred, for him to participate in a cross-examination and not leading to delays in trials. And this actually is a big contributor to delay in trials, that the officer is not being able to travel. So things that improves, it can change a lot. And the what's happening in Orissa is actually is like a great leap forward in many ways. So, a official lawyer, if he has an appeal, he actually need not go to the High Court. And in fact, the court is saying, listen, don't come. You go to this center, you sit there, the state has organized these facilities, and you participate from there. So I think that, in my view, can be revolutionary for this country, because we have talked about access to justice being a problem, and it is a problem. And we had Daksh had done a survey about 6 years ago, and I think you actually commented on that. I remember, is that how many percentage of disputes that need adjudication actually end up in the courts in this country? And I think it's a very low percentage. I think it's less than 5%, and the remaining actually get resolved by bodies that don't necessarily follow all the principles that we talk about. And whether that can go up and that can help in establishing the rule of law, that is something I think that is really exciting from an access to justice perspective.
I would also think that it's one thing to re-engineer current processes to allow for technology or to adapt them to technology. But I think another space where I think there's now possibility of maintaining the integrity of the system, but rethinking the way we do business itself. All our judicial processes are synchronous, right? The judge has to be there, both the parties have to be there, they have to be face to face, and only then can something take place. I think technology will allow us to start thinking, and the kind of technology that we have now, about why all of these processes have to be synchronous, right? Why does, and again, it should be thought of very rigorously, but if I'm applying if it's a purely formal process, does it have to happen synchronously? As long as there is a digital record that is maintained, that is foolproof, or that is the integrity of that record can be maintained, why does everything have to happen like that? I mean, there's a whole space of thinking there that we haven't even started exploring, because we are at that stage, possibly at stage 1 of adapting current processes. So I'm just wondering where the future will go with some of these possibilities.
Yeah, I think perhaps we should stop there, and because I think we have out of time. But it's interesting because there's in a way there's a push to reduce the time for oral arguments, but your thought opens up the door for unlimited oral arguments at your own leisure and without wasting court's time. Anyway, we'll stop there. But Anandita.
Thank you, Harish and Aparna. I now welcome Mr. Harish Chandra, the co-founder and director of Oakbridge Publishing, to address us. He is a specialist publisher of authoritative professional and academic works. Having started his publishing career with McGraw-Hill Education, he has worked for 25 years with leading publishing companies like Macmillan and LexisNexis.
Hi. Hello. Mr. Harish Narassapa, Dr. Aparna Chandra, ladies and gentlemen, judges in the audience. It gives me great pleasure in representing an extraordinary collaboration between Oakbridge Publishing and the Daksh team, with whom we are proud to share common values, principles, aspirations, the outcome of which is the book launched today. In an era where the world is constantly evolving and where the significance of democratic values cannot be overstated, this book arrives as a guiding light. The moment we first counted the manuscript, we knew we had stumbled upon something truly remarkable. From discussing the human dignity and rights of individuals to constitutional conventions and morality and values, the selected themes in the compendium covers a broad range of identities. Throughout the publishing process, we have witnessed Daksh's meticulous attention to detail and unwavering commitment to crafting a book that surpasses all expectations. They have been an active and engaged partner, working closely with our team of editors, designers, and marketeers to bring their vision to life. Their openness to feedback, their willingness to iterate, and their receptiveness to new ideas have made this collaboration a true partnership. To the authors, I must extend my deepest gratitude for creating this masterpiece. Their extensive research intellectual acuity, and literary prowess have given birth to a work that will undoubtedly leave an indelible mark on the minds of its readers. To the readers, I encourage you to open your hearts and minds to their words, for within these pages lie moments of reflection, inspiration, and profound wisdom. Thank you all for being a part of this momentous occasion. I congratulate Daksh, and may their literary journey continue to captivate and enrich all of us. I will be failing in my duty as a publisher if I don't call upon you to buy this book and see for yourself the kind of work that has gone into it. So thank you so much, and have a lovely evening. Thank you.
We have about 10 minutes for audience questions if anybody has a question.
Thank you very much for a good session. I just want to comment on the last part. You were talking about the technology. I spent almost 4 decades in technology and now moved over to law as a practice. We have to live with technology, and it's going to challenge us on many dimensions. Well, I heard Dr. Aparna talk about whether we should look at current processes or look at different way to achieve the same objective. We talk about digital reimagination to achieve that kind of impact. We may not be able to use the same process, but objective is to reach that effect of that. And technology is going to challenge us more and more. And we won't be able to manage the kind of paper load we see in a very lawyer's office, courts, wherever it is. There are millions and millions of past data as well, which will require an enormous amount of time. So my submission is we have to look at how we can digitally reimagine not only what technologies are already available at industrial strength today and what may be coming up in future, and adopt ourselves. I'll just relate a similar transformation India went through in financial services industry about 3 decades ago. We had huge amounts of paper in the securities market. The trigger of Harshad Mehta scam made the whole country sit up, and then that day's government took a decision boldly saying that we had to look at 3 things for that market: equal access from any part of the country, wherever they are, price transparency across the country, and efficiency of execution. Today, you see the amount of transparency that I have brought. And if we set ourselves across that kind of dimensions for the judiciary, I would call it transformation of judiciary use of technology by using appropriate, effective means of technology. And glad to hear some of the illustrations from Orissa, where many people don't have to come to the places where. And definitely, I talked to some of the Supreme Court advocates, particularly in many parts, Mumbai and others, about the COVID time. Thus, it was a great achievement. We could save a lot of time. We don't have to travel. Otherwise, for 1 hour of time to Delhi, we had to go 2 days, go and spend there. There's different types of efficiencies that may come up use of technology. And I think we all have to embrace a lot more than we see today. Thank you very much.
Thank you. Thank you, sir. Yes, sir.
Now that Justice Nagarathna is not here, catalog the disappointing judgment of Supreme Court. My question is to the academician.
Just name, stop at 10. Okay.
Sir, I teach constitutional law. I do this over 60 hours in a term, so I don't think I will be able to do justice to it at all. But I just want to say something more to what is leading to some of the disappointment, which is, we were talking about transparency, the lack of transparency in judicial reasoning. You would think that the thing that holds judges to account for the kind of powers that they wield is that they have to give reasons. But what we've seen over time, and I think it's really the fault of the academy that we haven't really that we haven't stepped up to the mark. But the kind of judicial reasoning that we see today, where invoking large ideals replaces actually the content of saying, okay, how does this actually make sense? What is the logical flow of this argument? How do we account for precedent that has come before us? So on and so forth. And I think that's a huge problem. And just to give an example again, because Justice Nagarathna is not here, it's her judgment in dissent, which makes in Kaushal Kishore, which is a judgment where the court is looking at the question of how rights apply, right? Do rights apply between individuals? And over her dissent, her very well-crafted dissent, the majority of the court says that, freedom of speech applies between individuals at a constitutional level. What does that even mean? Harish tells me to stop talking. Can I take him to court for a violation of my freedom of speech right? It makes, and this is a constitution bench decision. So just to say, I think what is leading to that problem, one is this role conception of what is the role of this court in its relationship with the other branches of government. And the second is the kind of very loose legal reasoning that we see even in the highest court and even in constitution bench decisions, which can be incredibly disappointing, not to say very difficult to teach to a bunch of idealistic 18-year-olds who think that every Supreme Court judgment carries with it a level of gravitas that we should accord to it.
Yeah, I'm not going to start, sir, because I did ask Aparna if she wanted to stop at 10, but I think she didn't accept the challenge. But sir, if I may answer that in a different way, not by pointing out the disappointing judgments. I think Aparna pointed out that I think in every judgment there'll be somebody who is disappointed, and that's the nature of the judicial profession. But I think what she alluded to was a judge has to live and die by the reasoning in his judgment. And I think reason is what separates the judge from what separates the judiciary from the other two branches of government, right? Because everything we do is supported by reason. That's why we sit in open court. There's no closed door meetings, there's no closed door hearings. But I think, sir, also, in a way, many of the challenges to the judiciary or many of the brickbats the judiciary has drawn to itself in recent times, particularly the Supreme Court, not so much the high courts, but particularly the Supreme Court, is because of many of the administrative reasons, administrative tasks that the judiciary has taken upon itself. It need not have taken upon itself. And at some level, merging the judicial function with that administrative function. One example, is that infamous and perhaps never to be seen again, special hearing on a Saturday to deal with matters of great constitutional importance. And I think that shows. It was a mingling of administrative action, administrative functions of a judge on the judicial side. You need not have, nobody asked it to be taken up on the judicial side. So in a way, the judiciary has to learn to deal with its power, which earlier judges didn't face that challenge in a way the current judges are, because they're more visible now. Earlier, except for the bar, the whole world did not know about what happens in court every second. Now we don't, I think judges and lawyers don't have that luxury of time to correct some of the smaller mistakes, some of the small mistakes that we can do. Now, that doesn't exist. So I think, while on the substantive side, I think there are many judgments we don't like, and I'm sure Aparna can draw up a list of 100 easily. I think the exercise of judicial power and the confusion of judicial power and administrative power of the judiciary, and the mixing of the two with judicial independence, I think is causing a lot of problems. And that's one of the challenges the judiciary will have to deal with in coming years. No, not at all. I think the list is too long.
The list is too long.
The list is too... Huh? 10.
10 from...
Yeah. No, 10 easily we can come up with 10. Yeah.
I think everyone, the only issue is, I mean, I'm happy to give a list of 10, but that will mean nothing because there will be my list of 10. I'm sure, Harish will have other lists. There are, of course, the landmark failures, right? So the landmark ADM Jabalpur, of course, that level of failure is a different kind of failure. I would place something like demonetization in that same bracket. I would put Aadhaar in that same bracket. But where I'm seeing the failure is that kind of lack of rigorous judicial reasoning. The confusion between what is the role of the court and what is the role of the political branches. And precisely to say that the difference between the judiciary and the political branches is the judiciary should not rule by fiat. But some of these judgments amount to that, because behind the obfuscation, right, 700-page judgment, and it amounts to very little because it's basically saying a lot without saying anything.
Yeah. It can't be essay writing and then one line at the end. I mean, it has to mean something. So that's the point we're trying to make. I think so. There are a number of judgments we're unhappy, but on a daily basis, many earlier judgments are overruled, many high court judgments. So in a way, there's a lot of it's part of the daily process where some earlier judgment is being deviated from. That doesn't make it necessarily bad or conceptually wrong. I think that's the point I think Aparna is trying to call it a day. I'll leave it to Anandita and Surya.
Hi, sorry. I just had one question.
Okay.
I know the part where you mentioned about the court crafting constitutional remedies to solve problems. Do you think that 32 and 226 and 227 as jurisdictional thresholds require reconsideration? Because if I'm in England and I want to take out a judicial review, I have to go to the High Court and take out a suit. In America, if I have to do it, I have to file a full-fledged suit. There's a trial. There's evidence that's taken. And this occurred to me recently during the same-sex marriage hearing. We had those 10 days of hearings, and no one bit of evidence was there pointing to, hey, this is a gay married couple, this is how they live. Because their evidence was not taken. So does the court's ability to craft constitutional remedies get hindered by the fact that all our constitutional cases end up becoming summary procedures instead of actual suits that have issues arising within them?
Thank you for asking that. That's a personal bugbear. I completely agree that we need to rethink what we think amounts to constitutional adjudication. Unfortunately, I think, and that's one of the results of the sort of expanding judicial role and approach, is that the Constitution has subsumed a range of other areas of law. Right? So tort law, for example, we have not developed, even if we want to hold the state to account for a pothole on the road, which is leading to a car accident, we need to go to the High Court or the Supreme Court, not because the law requires it, but because our imagination constricts us to say we are going against the state, we have to go to the High Court, Supreme Court, and because it's procedurally easier. Right? There's nothing that bars us from actually going to the trial court, to your local civil court under the CPC to enforce this. The only prohibition in the CPC is that, and in the Constitution is that the civil court judge cannot declare an act of the legislature to be unconstitutional. Otherwise, in cases of nuisance, in cases of public interest, so on and so forth, there are enough powers in the CPC, for example, for a local civil judge to look at, to decide on rights of a civil nature, which is what fundamental rights are. Unfortunately, what has happened is our constitutional discourse has overshadowed these other areas, and the consequence of that is that there are limitations, of course, to litigating a matter, as you yourself point out, in the constitutional courts, because you don't lead evidence, you don't try facts. That means that the ability to bring those facts is limited. Access to justice becomes that much more difficult, so on and so forth. So it's not just that other areas of laws have been impacted and we've not seen the kind of growth that we should see of other areas of law, including administrative law, but also that we've seen this upward shifting of constitutional discourse itself at the High Court and the Supreme Court level. It is really the business of the magistrate at the first instance, when I'm arrested and produced, to see whether procedures have been followed, not followed, whether my liberty has been unjustifiably denied or not. But magistrate doesn't necessarily think of themselves as a constitutional actor exercising constitutional power, though that is what the Constitution talks about.
Thank you for your questions. And in case you are interested in a list of judgments that Harish is disappointed in, you should totally buy this book, where Harish and I have written a chapter where we do list out some judgments we're disappointed in. I call upon my colleague Sandhya to give the vote of thanks. Yeah, it's been a very long evening, so I won't take too much time, but I have to thank everyone, so please bear with me. First and foremost, we would like to thank Justice Nagarathna for making time and joining us today. I think I would just, something she said resonated with me, so I thought I'll highlight that as well. It's about how she pointed out that we need to think about elevating constitutional ideals. So I think that's one way to think about everything that the Constitution stands for and how we should try and constantly increase the standard and not be complacent about it, and how we go about it is going to be really important. So I think that's something that would resonate with all of us and something for all of us to sit and think about. I would like to thank Aparna and Harish, of course, for touching upon the various themes of the book, because there's quite a lot of themes that the book covers. So I think they've done an exceptionally great job trying to touch the themes across the various spectrums and the dimensions that the themes deal with. We are actually very overwhelmed with all the honorable judges who joined us today and made time for us today. So we are extremely thankful to all of them who've joined us today. And I think this book would not be possible without the contributors. Something that I have to mention here is this might seem like something we've done over a year, but actually this started during the pandemic. So all of us at Daksh, we've actually, there have been times that we almost gave up, I think, but we've pursued, and our contributors have been exceptionally cooperative. I think a big round of applause for all our contributors. Thank you. Some of them couldn't join us today, but there are a few here, and I would like to thank all of them for being patient and working through this book with us. And we would also like to thank our publishers at Oakbridge, the entire team that worked with us over the last couple of years to help us put this volume together. Vikesh Dhyani, Harish Chandra, Priyanka Srivastava, and Bhupendra. A big thanks to the team at Oakbridge for helping us. And of course, thank you to BIC. They've always been exceptionally great at helping us organize our events. So thank you everyone at BIC. And I would like to specifically thank one of our colleagues, Harshita, who's our communication person. You wouldn't see her in the forefront usually, but I think a huge round of applause for Harshita, because she's put together a lot for us, making the promo videos and editing. So thank you, Harshita. I can't see you, but... And finally, thanks to all the wonderful audience who've actually patiently been here, engaged with the topic, and I hope that this has been a great evening. I know it's a Monday evening and everyone has a work day, so I'm really, really thankful that all of you made time to join us today. So thank you everyone. Have a very good night. Thank you.